BZA-Z.
Aye.
Obviously, we have the appellant and his attorney. You probably have some public comment, and then you have the conference room if you decide that you all need some executive session direction. And
All right.
I think that's it.
All right, sorry to keep you all waiting. So if maybe y'all could work it out. All right. This is the March 10, 2026 meeting of the City of Charleston Board of Zoning Appeal and Zoning. Present here today are Gordon Huey, Chappie McKay, Allison Grass, John Bennett, and me, your chair, Jeff Tibbles. Present from the planning staff are Robert Summerfield and Chris Walha. These proceedings are being recorded, and we ask that those who speak, please identify yourself for the record. We will conduct this meeting in the usual fashion. We will first receive information from city staff about the application and the recommendation. If the recommendation is favorable and no one objects to the application, the matter is uncontested. The Board of Zoning Appeals usually, but not always, approves uncontested applications. For all applications, the board reserves the right to ask questions of the staff, applicant, or others in attendance prior to rendering a decision. If, however, the city recommends against the application, or if there is opposition to the application, we treat the matter as contested, and we hear from the applicant and anyone else who is in favor of the application. Next, we hear from anyone opposed, followed by a short rebuttal from the applicant. We then close the public hearing portion of the meeting for that particular application and open discussion to the Board of Zoning Appeals members only. We will then make a decision to approve with conditions, or deny the application. The Board of Zoning Appeals Zoning has the authority to do three things. Number one, hear appeals to the zoning administrator. Number two, grant special exceptions, a fact-finding function of the board. And number three, grant variances to the zoning ordinance if the application meets the hardship test outlined in section 54-924 of the ordinance. The board may deliberate and make a final decision on a matter by a majority voted members present at the hearing and qualified to vote, provided that not less than a quorum is both present and qualified. However, an affirmative vote of 2/3 of the board members present and voting shall be required before a use variance may be granted. For variance to be granted, the Board of Zoning Appeals must make the following findings: A, that there are extraordinary and exceptional conditions pertaining to the particular piece of property. B, these conditions do not generally apply to other property in the vicinity. C, because of these conditions, the application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. And D, the authorization of the variance will not be a substantial detriment to adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance. We do have rules on the conduct of our hearing. We have, and I understand tonight is a special meeting relating to an appeal of a zoning administrator decision for any application by an applicant or appellant. We have a 10-minute limit on a presentation, and that's cumulative. We have a 10-minute presentation limit for the opponents. That's cumulative. We do have a rebuttal time limit by the applicant for 3 minutes. As the chair, I can extend those time limits, but I do ask that you extend us the courtesy as volunteers here for this special meeting, that you try to keep your comments succinct and that you try to avoid repeating things that others have said. All right, so I'm bound by our city's ordinance to ask you to tell the truth. So if you do intend to speak, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. You'll signify by saying, "I do."
I do.
All right, we've got one item on this evening's agenda, and it's A. Let's see. A is reviewed in minutes. I don't know that.
No, it's A1.
All right. So A1 is 657 King Street, Cannonboro, Elliottboro, Council District 4, TMS number 460-04-04-091, zoned GB. Appeal of zoning administrator's determination regarding location of the height district boundary pursuant to section 54-306 Old City Height Districts. The owner is 657 King Street LLC. The applicant is E. Brandon Gaskins, Moore Van Allen, PLLC. Mr. Summerfield.
Mr. Chair, members of the board, so this is regarding the appeal that's before you this evening is related to my December 3rd, 2025 determination that the boundary between two height districts that bisects the property at 657 King Street was not ambiguous or uncertain in its location. As stated in my issued response to the remand, because this was remanded to the zoning administrator by a judge in a separate appeal, it is my opinion that there is not ambiguity as to the height district boundary line, that the GIS maps that the zoning division uses are accurate and can be relied upon for zoning purposes and planning purposes, and that due to this being an appeal, my determination, staff will have no recommendation to the board, but obviously is available for any questions related to this matter. This is just that determination that I issued based on the remand. This is the height district map in question. You can see where the two different height districts are here on the map and the relationship on the property. And there were some other elements in this. I don't know why they're not showing. So with that, Mr. Chairman, members of the board, that is all I had as an introduction. We do have the appellant here, and he had some extensive components, so I need to figure out how to get those back up. And I will do that while he introduces himself.
All right, Mr. Gaskins.
Good evening, members of the board. I'm going to turn it over to 657 King Street LLC's principal, Colin Colbert, to make some introductory remarks, and then I'll take it over. All right. Good evening. My name is Colin Colbert, and I'm with CKC Properties, the developer for 657 King Street. I appreciate the opportunity to provide the board with background on how we arrived here tonight. We began the Board of Architectural Review process in December 2024, submitting a building plan that incorporated a step up in height. At that meeting, the BAR denied the proposal and directed us to revise the design to be more consistent with a maximum 5.5-story building. Following that meeting, our architect asked city staff a straightforward question. Where exactly is the line on the property that separates the 4-story height district from the 6-story height district? Staff advised us that they could not determine the location of that line with any certainty, and as a result, we were told the height limit defaulted to the least restricted ordinance, allowing 6 stories across the entirety of the site. This interpretation was not something we requested, encouraged, or attempted to influence. We did not engage an attorney, nor did we advocate for any particular outcome. We simply asked where the line was located and relied on the city's response. That same interpretation was explained by city staff to the BAR at the March 2025 meeting where the project was deferred, and again at the May 2025 meeting where the project was ultimately approved. Relying on this guidance and proceeding in good faith, we invested hundreds of thousands of dollars and countless hours redesigning the project exactly as directed and obtaining the necessary approvals. In June 2025, our BAR approval was appealed by the Historic Charleston Foundation. This came after HCF had initially emailed our design team on April 30th stating that, well, they were not going to oppose the project and appreciated our willingness to incorporate BAR and preservation group feedback. It was not until the day of the meeting and approximately 2 hours prior that HCF altered its position and notified our team via email stating, quote, "We are sorry to introduce the concerns at the last minute, but we must comment on the split zoning concern as it creates a dangerous precedent for other properties." Once the appeal was filed, we retained Brandon to help navigate the situation. This matter proceeded to circuit court where the city strongly and unequivocally defended its interpretation of the ordinance alongside us. During this same period, city staff proposed and planning commission and city council approved an amendment to the zoning ordinance designating the city GIS scale as the official method of measuring the zoning district boundaries. This amendment was intended to correct what the city itself viewed as a flaw in the existing ordinance brought to light by our application. The amendment ultimately addressed and resolved the HCF's concerns about the precedent this approval might have established. Eventually, the circuit court issued a brief ruling remanding this matter back to the zoning administrator. And it was at that point, and to our surprise, the city reversed its position, concluding that it could now determine the location of the boundary line between the 4- and 6-story districts with absolute certainty. This reversal is what brings us before you tonight. This change in position is particularly troubling because the city's original interpretation was based on the reality that the underlying county tax map on which the zoning line is overlaid is inherently inaccurate. And if the line's position lacks fixed reference points such as property lines, as it does on our lot, it cannot be accurately defined. That reality has not changed. In short, we followed the city's direction at every step, obtained approvals based on that direction, and watched the city defend that interpretation in court while simultaneously amending the ordinance to prevent this issue from occurring in the future. Only after remand from the judge did the city reverse course. This type of reversal undermines the integrity and predictability of the planning process. Applicants must be able to rely on official interpretations of the zoning code without fear that those interpretations will later be abandoned due to political or external pressures. For these reasons, it's imperative that the Board of Zoning Appeals overturns the zoning administrator's decision, upholds the integrity of the land use process, and ensures that the ordinance, not shifting interpretations, governs development in our community. I'll turn it over to Brandon to walk through the technical details, but I felt it was important the board understands the circumstances that have led us here tonight. Thank you.
All right, thank you, Mr. Colbert.
Good evening, members of the board. Again, my name is Brandon Gaskins and I represent 657 King Street LLC. And I also want to thank y'all for accommodating us with a special meeting. I know y'all didn't have to, but we appreciate that. But this appeal turns on a single issue. Can the city declare certainty about a zoning boundary it has repeatedly admitted it cannot precisely locate after the applicant relied on the city's earlier position, obtained approval, and defended that approval in court? And the answer to that question is no. The zoning administrator's determination that the location of this boundary is not ambiguous should be reversed for two reasons. One, he should be equitably stopped from now claiming certainty after his prior involvement in the prior representations. And then secondly, turning to the merits, the record establishes that the boundary is ambiguous as a matter of law and fact, triggering the application of former zoning code section 54-103C. And I'll begin with the estoppel argument. South Carolina law is clear. A zoning official may not reverse a prior interpretation when a property owner has reasonably relied on it to their detriment. And that is exactly what has happened here. After the BAR denied the initial proposal in December 2024, city preservation and planning staff expressly told the applicant that the exact location of the Height District could not be determined with certainty. And based on that uncertainty, staff instructed the applicant to redesign the project under section 54-103.C, which applies only where uncertainty exists. Critically, the zoning administrator was fully aware of and involved in that decision. The record shows that months before the approval in May 2025 by the BAR, that he was aware of this issue. He received internal notes from city preservation and planning staff describing the property as split in the 4-6 height zoning and explaining that staff encouraged 5 stories across the entire building because of that split. He was also aware of the preservation group's opposition to building more than 4 stories along King Street, but nevertheless, he joined in that recommendation that the BAR approve the 5-story design. And at no point, before approval, during approval, or during the litigation, did he say that the boundary was certain and did not apply. And as you've heard, 657 King relied on those representations that redesigned a complex hotel project multiple times, incurred significant professional fees and delay costs, and defended the BAR's approval in judicial proceedings, all based on the city's express representation that the boundary location was uncertain and that this code provision applied. And it was only after remand that the zoning administrator reversed course and for the first time found the location to be not ambiguous. And this is precisely the type of unfair reversal that equitable estoppel should prevent. The city cannot approve a project on the basis of uncertainty, allow the applicant to rely on that position, and then retroactively declare certainty once the approval has been challenged and remanded. So for that reason alone, we believe that the zoning administrator's determination should be reversed. Secondly, turning to the merits, even if estoppel does not apply, the zoning administrator's determination fails on the merits. The conclusion that a zoning boundary is not ambiguous requires a fixed, objectively determinable location. But the zoning administrator's determination that you just looked at does not identify where that actual boundary is. We have never been provided that information. All we have is his determination that it is unambiguous and certain. And despite our request that he do so, the zoning administrator did not provide the map that he relied on, whether the boundary is measured from a property line, right-of-way, street center line, or some other point of reference, coordinates for where the boundary intersects the property, or any consistent methodology for locating it. In short, he declared certainty without supplying a single measurable fact. But the record shows, based on what we've been able to obtain since his determination, that will by the map itself, you can see that it does not follow an established lot line. It intersects the boundary, which makes it difficult to determine. But it's also not clear if it's based on the property line or the center line. And we've included in the materials that we submitted that this was an issue that the GIS analyst and planning staff were aware of when they were amending the Height District map in 2017. It was specifically brought up that this could be an issue if more detail was not provided. And that detail is not included in the GIS data, and is certainly not included on the GIS maps, and it's not included in the ordinance itself or in the legislative history. What we've also seen is that these polygons, which are digital shape files that are overlaid onto another map, are created by the city and then overlaid on the county's GIS map, who the city GIS officials and planning officials admit they cannot confirm the accuracy of the information in the county's GIS map. These GIS employees have also confirmed that the GIS maps are not reliable for this type of determination. These are the experts in their field, and they oversee the creation of and the maintenance of the zoning maps. And they admit that these tools do not allow the locations of boundary lines that intersect properties to be determined with certainty. I'd like to pass out, this is included, but I think it's especially important in case y'all haven't had a chance to go through everything that we presented. If y'all not, I would pass this out. So what this is an email in 2021 based on the same Height District maps that are at play at issue here. And this was about a question at 483 Meeting Street. And Meeting Street, like King Street, also has a buffer area where the boundary lines intersect properties. And so the engineers that were working on this project sought clarification. Where exactly is this buffer line on the property? And that question was directed to Brian Pokrant, I'm not sure how you pronounce it, but he's the one who was also involved in drawing these maps. And his answer to that is very telling. The height district for this parcel appears to be very close to 50 feet from the front of the parcel. My guess is that the description or intent in the ordinance would state that the height district 5 is to be 50 feet back from the front of the parcel at Meeting Street. GIS data is not survey grade and generally should not be used for construction unless specified otherwise. So here we have the expert, the city's own GIS expert, saying that these GIS lines should not be relied upon for these types of determinations. And not only that, after we got the zoning administrator's determination, we had a meeting. The city was very accommodating to us, allowed us to meet with Mr. Summerfield, and then allowed us a follow-up meeting with the GIS staff. And during that meeting, which we have confirmation of in writing, which is provided in the packet, the GIS director stated that the GIS tools provide only, quote, a good ballpark, unquote, or quote, a pretty good estimate, unquote, of the boundary's location, and that a survey would be required for precision. So a boundary that can only be approximated is by definition ambiguous. That conclusion is reinforced by the independent GIS expert whom we retained in this matter, and he explained that the apparent location of the boundary can shift as underlying parcel data is updated, meaning the boundary does not have a single immutable location. It may be where it is depicted on today's GIS maps may not be where it was depicted when the map was adopted in 2017. And when I show you the map, you can see how that's possible. Not only that, the zoning administrator's post-determination conduct in his meeting with us confirmed the problem and difficulty in establishing this line with any certainty. When he attempted to measure the boundary using the city's GIS tools in the meeting that we had, the results varied and did not consistently equal a certain measurement, much less one that was 50 feet from the property boundary. The measurements that he made also conflicted with the measurements of the property lines and right-of-way dimensions as reflected in recorded plats created by licensed surveys. That inconsistency is not incidental. It is the proof of ambiguity. And former section 54-103C exists precisely for such situations like this, where a zoning boundary divides a lot of record and cannot be precisely determined. Declaring certainty here does not apply the ordinance, it nullifies it. So in sum, the zoning administrator has reached a conclusion that has been consistently rejected, not only by our expert, but more importantly by the city's planning and preservation staff, the city's attorneys, the city's GIS analyst, and the city's GIS director. His determination is also contradicted by the city's official Height District zoning map. I'm going to pass this out as well. This is the map that was adopted in August of 2017 and was provided to us by the city in response to our FOIA request. And I hand this to you because it has a very important disclaimer that is on the bottom. That disclaimer that is blown up was not original, but it is to the left, but because it's unreadable, we wanted to blow it up to make sure that you could read it. And it says, important disclaimer notice. The city of Charleston makes no warranty, representation, or guarantee as to the content, sequence, accuracy, timeliness, or completeness of any information provided herein or derived from the mapping data for any reason. So the city's own map states that it cannot be relied on for certainty. And in fact, Mr. Summerfield's determination conflicts with his own prior involvement in this case, where he supported the BAR's granting of conceptual approval to this project under section 54-103.C. So given all of this evidence, it's clear that his determination that the location of the Height District boundary is not ambiguous, that determination was an error. And finally, I want to appeal to you on a practical level. We have a design of a hotel that was encouraged by city staff and that was approved by the BAR. Now, obviously, you've heard the background. There was an appeal, but importantly, the Historic Charleston Foundation didn't have any objections to the design, except out of concern that the BAR's conceptual approval of this project could establish bad precedent that could be applied to other properties. And that's what they stated to the applicant. But that concern has been eliminated. former section 54-103.C has been eliminated. It will not be a problem any longer. So there is no concern that you will establish or that the BAR has established any bad precedent. So in conclusion, principles of fairness and common sense dictate that the zoning administrator's determination should be reversed, and we respectfully request that you do so. Happy to answer any questions that you may have.
Thank you, Mr. Gaskins. I do have a few questions for you, and I hope everybody will indulge me because it might take a little bit. So on the estoppel issue, if we can just focus on that for a second. With respect to estoppel, is that a decision that this board can make in order to overturn the zoning administrator, or is that better left to the purview of the courts? Shouldn't we be determining whether the zoning administrator was correct or not in his ruling? And isn't estoppel a common law doctrine for the courts?
It is a common law doctrine, but I'm aware of no precedent that would preclude this body from making that finding, especially when you look at the posture of how we got here. Because part of our request to the zoning administrator was not just a determination of the location of this boundary, but also for confirmation that he was involved in the prior decision before it got BAR approval. We did not receive an answer to that request. That was ignored. So even if you don't look at it as an estoppel issue, I think it is within the scope of our appeal because we requested that, we did not get it, and now the record reflects that he was in fact involved in that decision. So whether it's under estoppel or just looking at his determination based on our request and the facts not matching up, I think the board has that authority.
With respect to the representations, I know that you alleged that city officials or a city official or city officials told your architect that the boundary location was uncertain. When did that happen? Who did it? And was that in writing?
So I don't know exactly when it happened. I would assume that this would have been sometime between December and March when the property was being redesigned and they were trying to figure out the height. That was made to the engineer by Ms. Ashley Jennings, who's here today. And I believe that representation was made, was it by?
Who was the city staffer that made that representation?
The Wortham Galvin.
Okay. And that was made directly to Ms. Jennings?
That's my understanding, yes.
As a representative of the owner here?
Correct.
Did you ever receive a written determination from the zoning administrator himself that the boundary was uncertain and 54-103C applied?
No, we did not receive that
Could
representation.
you have done that? Doesn't our ordinance allow you to obtain an opinion from the zoning administrator as to whether or not it's uncertain?
It does, and certainly if that would have been presented to us, that would have been an option. But that was not the way things played out. There was never any question about whether this applied based on the representations of the city staff. That this boundary line was uncertain, therefore 54-103C applies, and the 6-story height district can apply throughout.
So in other words, you saw no need to request a formal opinion or decision of the zoning administrator because you had already been told by city officials or city staff, or at least one staffer, that uncertainty applied. Is there a meaningful difference in your mind between informal staff guidance during a design process and a formal zoning determination? Don't you think there's a difference?
I'm not sure that there is. I think that a developer, a property owner has a right to rely on the representations of city staff if those representations are made within the scope of their authority, which is what happened here. So whether it was informal, and it wasn't just informal, this was discussed at both BAR meetings. It wasn't any secret. The staff member was on the record saying this ordinance section applies. So I don't think a formal determination would have changed the posture in any way.
Let's talk about the money side of the estoppel reliance side. So do you have a number that you can present to the board? I assume that there is some, there's a claim that there's some amount of money that's been expended in development costs that is, for lack of a better term, wasted in the event that you can't build the plan. But I would assume that there's some money that's been spent that would be, still useful for building a 4-story instead of a 5-story hotel. So do you know the delta? Do you know the amount of money that that we're talking about when we say, because I've heard hundreds of thousands of dollars in some development costs by Mr. Colbert, but I don't know how much we're really talking about between. Do you see what I'm saying?
I do see what you're saying, and I have not quantified that precisely. Okay, obviously, Mr. Colbert does it.
Obviously, some of that money can be used, design plans. I don't know if you did a survey. I don't know what all you spent money on, but I would assume some of it can be salvaged, but some of it cannot.
We're hoping we don't have to find out what that's on.
But you don't know the specific amount today.
No, not
All right. Let me ask you about this uncertainty and the alleged uncertainty. Can this line be precisely located in your opinion?
No, and I think that's confirmed by the information that we've included in the record. Again, if you look at the emails that were shared between city planning staff and the GIS analyst at the time, there's a clear discussion about this and about the uncertainty that can arise if there is not additional information, especially in the legislative history. Now, what would have been nice and which could allow that certainty is if city council said, yes, we have this 4-story buffer that runs along King Street and extends to 50 feet or whatever the measurement is beyond the property line. But city council didn't do that. What they did is it adopted a map created by staff who said that this is going to create issues if it is not defined more certainly. Beyond that, in 2021, the email that I just showed you, we have the GIS analyst saying this should not be relied on for construction. This is not survey grade. So he says to look to the ordinance so you can determine that intent. But if you look to that ordinance, and it's I believe it's Exhibit 1 to my letter, there is nothing in there that would allow you to glean what city council's intent was in creating this buffer area along King Street. You have to use the map and make your best guess, but you cannot determine it precisely. And that again was confirmed by the city's GIS director when we met with him after the zoning administrator's determination. In his words, not mine, his. He said it is a good ballpark. It is a pretty good estimate. And then on top of that, we engaged our own expert who confirmed the city GIS director's opinion. So no, I do not believe it can be determined precisely.
And if that's the case, wouldn't that be true for every high district boundary that crosses a parcel so that it's always uncertain? And if it's always uncertain, wouldn't that render the split height zoning scheme unenforceable? I
think unfortunately it would, but which is why I think city council amended the ordinance. So now when these questions come up, the zoning administrator can pull up the GIS and come up with an approximate location of that boundary. And it's not going to allow the least restrictive zoning or height district to apply to the entire parcel. So I think that was a flaw in the code, the way it was drafted, but it has since been corrected. And my client should not be penalized for city council's failure to provide that clarity.
Okay, understood. And so we can't tell, in your opinion, how much of the building's footprint falls within this disputed area where the boundary might be under different interpretations. We just don't know.
Not precisely. I mean, we can have a pretty good guess.
To what degree, you think?
That I'm not qualified to say, but it's clear that it's not precise, whether it's.
You not coming here with an opinion of certainty saying that it's within I mean, you want it to be within 50 feet, is that right? I mean, I guess it does matter to you because uncertainty is enough, but within 50 feet would give the height that you were looking for.
Correct.
So, but you're not here giving anybody, you're not espousing some opinion that yes, in fact, this line can be determined and it is within 50.
That is correct. I am not. And in fact, when we met with the zoning administrator, he could not determine it with any consistency either.
Right. Yeah, saw that. All right, so now a few questions about what may happen. If the board reverses the zoning administrator and finds that the boundary is ambiguous or is uncertain, then what happens next? Does that repealed ordinance still entitle you to apply the High District 6 across the whole parcel or not?
Yes, under the time of application rule under Pure Oil, which I would think you're familiar with, the time of application rule would make a former 54-103.C applicable.
Okay. And so, okay, and so the path for you would be zoning administrator overturned, you're still under the old ordinance and you proceed under the old ordinance.
Correct.
And there's no pending ordinance doctrine issue here that your application was in before the first reading or public notice.
Right.
Like that.
That's correct. This amendment was a direct result of Historic Charleston Foundation's appeal and then bringing up this issue. So, which we just talked about in an effort to correct that issue. So.
Did you ask Mr. Miller to see if he could determine exactly or precisely where the line is, or did you ask him that?
Did I ask him? Well, I don't know if I asked him to determine it precisely. I asked him, could it be determined precisely?
And he said that. All right. My fellow board members might have other questions for you. I didn't cover anything. Feel free. Okay, thank you, Mr. Gaskin. And then anything anybody else has to add in support of the appeal? Support of the appeal? All right, so seeing no one else in support of the appeal, we'll hear from opposition to the appeal. Tell them.
That's where I stand. Thank you. I just have some things to hand out as well. Simple overview with a couple of points I'm going to talk about. Good evening. I'm Brian Hellman at 105 Broad Street. I'm here tonight representing King Street Holdings, who owns 648 to 658 King Street, which is diagonally across King Street and under the crosstown and over from the subject property, as well as Historic Charleston Foundation. With me tonight from Historic Charleston Foundation are Winslow Hasty, Lisa Jones and David Maybank. Ms. Jones was present at the BAR meeting that was appealed and ultimately the basis of why we're all here tonight. The BAR, as you heard, misapplied 54-103, and Ms. Jones brought that up. She said, there's no one's talked about uncertainty, the gating issue for 54-103. Ultimately, that led to 2 more stories, a 50% increase over half of this property. There are plenty of ways to get 2 more stories. There's variances, there's the merit-based opportunity under the architectural review ordinances, as well as a rezoning. At the appeal, we heard the same arguments that you heard tonight, and Judge McCoy remanded because she found that the zoning administrator, nothing in the record showed that Mr. Summerfield had made the determination that he needs to make under 54-103 as the basically gating point to even get to 54-103C. And when it was remanded back to Mr. Summerfield, one of the comments that he made in a response, he said, nobody came to me for this determination. Nobody ever asked. And then he said, no uncertainty exists. And I think that speaks to the estoppel argument. One of the questions that you raised, Mr. Chairman, was, can you rely on staff as opposed to a formal decision or determination by the zoning administrator? And our courts have addressed that. One case was the City of Charleston case, DeStefano versus City of Charleston. And in that case, our Supreme Court held that no estoppel can grow out of dealings with public officers of a limited authority. And the doctrine of equitable estoppel cannot ordinarily be invoked to defeat a municipality in the prosecution of its public affairs because of an error or a mistake of one of its officers or agents. Furthermore, in South Carolina Coastal Council versus Vogel, the Court of Appeals said the public, meaning the city, cannot be stopped, however, by the unauthorized or erroneous conduct or statements of its officers or agents which have been relied on by a third party, tonight's appellant, to its detriment. In other words, they should have received and obtained, when this issue of uncertainty existed, a determination very early in this process from Mr. Summerfield. But they didn't, and we find ourselves here. The issue before you tonight isn't really about where the boundary exists or their property boundaries exist. It's where the boundary between 2 height districts, the 4-story and 6-story district, are in relation to each other. And in that instance, if you read the beginning of 54-103, it says, where uncertainty exists with respect to the boundaries of the Old City Height districts, as shown on the map, and here I'm adding Old City Height districts, uncertainty exists with respect to the boundaries of the height districts as shown on the zoning map. It's not the boundaries as it relates to property lines or right-of-ways or where it intersects. It's where those boundaries meet each other. And here, the board's analysis tonight is to focus on the boundary, those 2 boundaries, not how they touch property lines, because what you'll read in some of the emails from the city is that the Old City Height District layer stands on its own. It uses polygons. In the record produced to you in this very large stack that we all read from the appellant, that you'll read comments that there are fixed geographic coordinates that identify the location of the district boundaries. The height district layer of the zoning map can stand on its own because precise coordinates are known. And these height districts are not necessarily tied to property lines or rights of way, particularly the way these height districts work. And the city cannot verify property boundaries. These are all in correspondence and emails, ones that were referenced by Mr. Gaskins.
And I apologize because I did not interrupt Mr. Gaskins, but this is important enough for me to want to know. If they are GPS coordinates, do you have some kind of a map showing with certainty where that line is?
So my understanding from my review of the record and the discussions with the city is that the Old City Height District layer, where the 4 and the 6-story district meet, that there are precise geographic coordinates, which leads us to the next point. Those coordinates, just like you would do with a FEMA map in flood zones in a survey, You take those coordinates and a surveyor gets them, and the surveyor puts them on a survey. Because the one item that is missing in this entire package of documents is a simple survey where you go to the GIS department, you get the precise coordinates, the surveyor puts those precise coordinates. And as Mr. Summerfield said, his GIS tools are not a substitute for a survey. He is not a surveyor, but you take that information, you put it in a survey, and the surveyor can determine based on where the property marks are, where King Street is. King Street is not a straight line, Mr. Tibbles. If anyone knows right of way, sir, it is you. So the only way to determine that is with a survey, the one document that was missing. So it's not what appears in the record, it's what doesn't appear. And the height district, from what you can read in the record, is known. Where those boundaries are, it's known. And there are, I quote, fixed geographic coordinates that identify the precise location of the boundary. That doesn't mean they can take that boundary and use, the city is not an arbiter of property lines. It is not an arbiter of right-of-ways. I mean, I could only imagine the constitutional law issues that would come out of that. So where we're concerned here is there is certainty as to these boundaries. And those boundaries, just like you would do if you were going to identify where the flood zones change on your property, you get the data, you give it to a surveyor, the survey says, here's where it is.
Isn't GIS notoriously imprecise?
I'm not a GIS person, but what I read in the record said that there is fixed, precise coordinates, and Mr. Summerfield and other members of the GIS department said, give that to a surveyor, they can put it in a survey. So, I mean, ultimately, I think the issue before you tonight is one footnote 1 of the letter that I handed you addresses estoppel, when it's not Mr. Summerfield making the representation or determination. And secondly, the issue before you is not one of how this 4- and 6-story boundary intersects properties or hits right-of-ways or the distances from property corners, as was asked by Mr. Gaskins of Mr. Summerfield. It's, do we know where this 4- and 6-story boundary is? Are there precise coordinates? The record reflects that there are, because the next step is the record also reflects in an email of the meeting minutes that Mr. Gaskins was talking about between himself and the GIS team and city lawyers. They said, we'll give you the precise coordinates, go get a survey. I believe it's exhibit 19 of his package. They said, go get a survey. And that just hasn't happened. And it didn't happen from the beginning. And it's shocking to me. I generally represent developers. And the first thing we do is we get a title search and we give that information to a surveyor. And the surveyor gets information from FEMA. And if there are zoning districts that are at issue on a property large enough, that surveyor goes to the municipality or the county and gets information to show that on a survey. And it's shocking to me that that wasn't done here. That's the one piece that's not in this that would have stopped this from the very beginning. And
I think you made the point about the zoning administrator opinion as well, but I won't belabor that. You got more?
that's it.
Okay, so I got a couple questions for you too. You're not off the hook there. What does ambiguity or uncertainty mean in this context? Does it arise whenever the boundary can't be located with survey grade precision? And if so, I mean, why is that provision even in there about uncertainty if you can determine the exact location through GPS coordinates? What's the point?
I asked Mr. Batchelder about that.
Yeah.
Hoping that there was some institutional knowledge. And Mr. Batchelder reminded me of the early days of my practice before the GIS system was fully integrated. And he would roll out this like giant map, maybe they're still around. And you had all these little properties and all these lines, and you had a bunch of black lines and colored lines, and they all bled together, and you're looking at it, bringing out, a magnifying glass, and you can't figure out what anything is. He said,
Was the ordinance passed the original ordinance on the height district, was that passed before the widespread acceptance of GIS and GPS technology?
I don't know the date that it was passed, but that's what Mr. Batchelder said, that his recollection of why they were using
And
that.
it could be remnant language, we don't know. You haven't studied legislative history, I don't know that I have, maybe Mr. Gaskins has, I'll ask him about it. All right, so if the boundary can be, yeah, if the boundary can be determined with precision, then I suppose that would be sufficient to enforce a height regulation. Right? I mean, obviously, it's only where there's uncertainty, and what you're telling us is that it can be defined with certainty, but maybe it hasn't yet because the survey hasn't been shown. So do you know, and I'm gonna ask some questions of Mr. Summerfield as well. He's not getting off the hook either, but how can Mr. Summerfield make a determination of certainty if he doesn't have the survey in front of him?
Well, I think that when the precise geographic coordinates that identify the district boundaries, to use the lingo from the GIS people in the December 30th email, when those coordinates are given to a surveyor and the surveyor certifies in a survey, this is where it is with the coordinates that I given. I think that.
But he didn't have the benefit of a survey, right? So he's just, you know, and I'll ask you, Mr. Summerfield, I don't mind going ahead and asking you now. Did you apply these specific GPS coordinates and making your determination and decision?
Yes, so in opening GIS, I turned on the layer. I looked at the information for that layer. It gave me specific details about where the box is. And as has been mentioned, again, GIS is a planning tool. It's not for construction purposes. I think that's been clearly noted. That's why our construction permitting requires a survey in order for you to submit permits for construction that have all of that stuff. But we don't require a survey at time of you coming in for a conceptual review at BAR or even for BZA-Z. That level of detail is not required. We rely on the city zoning atlas, which is the GIS map, and the various layers that we have, and the data is all underneath it.
Okay, so you use GIS.
Yes.
So you didn't use a survey with geotechnical points to make that determination as to certain.
No.
But I think the certainty is as to the boundary under 54-103, not as how the distance from various property lines, because those property lines.
Don't you need to know both to make the determinations, the split?
I think the surveyor is the one who
Right.
would identify it, no different than
Okay.
you can look at a FEMA website and see that there's a
All right,
FEMA line.
so what you're saying is the ordinance language says if there's uncertainty with respect to the location of the zoning district?
So 54-103 starts, if uncertainty exists with respect to the boundaries, and then in this instance of the Old City Height districts as shown on the zoning map. It doesn't say as it relates to
Okay.
property lines or anything else.
I hear you.
Solely as to the 4- and 6-story, where are they?
All right.
That we know with precise geographic coordinates.
I have a question.
Go ahead.
Is that data coming from the GIS system?
So
Those
my understanding from that, from what I read in the record that was produced by Mr. Gaskins, that information is on a height district layer that stands on its own, basically only with coordinates of height districts.
But it's very, it's part of the GIS. Even, let's say, yeah, you can extract the data, but it's stored within a GIS system.
That's my understanding.
Okay, it's
Mr.
not,
Summerfield may be.
it's not on a platted survey or any other survey document of any kind. It's strictly.
I don't know the answer to that, Mr. Summerfield.
It's a layer within our GIS database.
Gotcha. All right, I want to ask you the same question because I want to make sure that at least people are on the same page on some issues. If the board were to grant the appeal, then there is the time of application rule, and they would still be treated under the ordinance prior to the amendment. Is that you agree with Mr. Gaskins on that position?
I don't think we disagree on that.
There's no pending ordinance here. They would be governed by the old one.
Familiar with Control Oil.
And then with respect to the standard of review, do we owe the zoning administrator any deference here, or are we supposed to undertake a de novo review of whether or not he was correct?
I'm going to let you guys decide that.
Good call. We always give Mr. Summerfield a healthy degree of deference, but legally standard, something that we may want to talk about in executive session. All right.
I have a question.
Go ahead.
I just want to make clear on the coordinates. You're saying that like I, as a user of the GIS, I can get online and I can find these exact coordinates that you're describing.
I'm not saying that. All I'm saying is I read in the record that the GIS department of the city has these coordinates and can provide them to a surveyor. And in that exhibit 19, they in fact said you needed to get those coordinates and get a survey so that you can take those coordinates and determine where this line is in relation to your property boundaries.
So the city has the information, but it's not accessible to a user online, right?
Right. My understanding of the online system is it's there as a general guide.
Okay.
But Mr. Summerfield again could probably better answer that question.
Mr. Hellman, I don't doubt that historic Charleston has some standing here to address this issue. What about your other client? What's the other client's interest, and why is that client opposed?
They have of course, a substantial interest as a across the street neighbor of this property and are concerned given the reading of the zoning code as it relates to this property versus their property.
Are they alleging that there would be some harm to them if the appeal were granted?
I believe so. That's why we're here.
Okay. And do you know anything about the nature of that harm, or what they would contend in the way that they might be harmed?
Well, that their property would not be treated with the same degree of deference that this property would be treated. That the prevailing law would indicate that it should be a 4-story district and a 6-story district with a known boundary, and that and it's not, and effectively leading to 2 more stories over about half of their property.
Am I reading the zoning map correctly that their property would be in a split 4-8?
I'm not certain.
I'm sorry. The properties you're referring to, are they in a 4-6 or a 4-8 zone?
They're in a 5 zone.
Oh, they're north of, okay.
Yeah, this is
Thank
just a static screenshot of.
Sorry, I
GIS
was
layer.
imagining it was across directly.
It's diagonally across the crosstown in between, or the 17 or.
Septima Club.
Yep. Yeah, now known as Septima Clark.
Any other questions for Mr. Hellman?
Thank you.
No, thank you, sir. All right, before we will get to you 100%. You'll get a chance to full some opportunity to rebut. But I do want to. Does anybody else want to speak in opposition? Yes. Thank you.
Thank you. I will start with your question, which you did not pose to me, but I think it is important. I think this is a de novo review.
Okay.
Under 629, 800, which says that the BZA sits in the shoes and on an appeal in the shoes of the zoning administrator.
Very good.
With respect to the issue about these coordinates, I do want to address that because I think there's one, we specifically requested that if Mr. Summerfield determined that this boundary line could be determined with location, to tell us those coordinates. We got no response. You've seen his letter. He doesn't say what the coordinates are. He doesn't say where the boundary line is in relation to any other point of reference, which you have to have. I haven't heard anybody today, Mr. Summerfield, Mr. Hellman, tell us where that boundary is, whether it's in relation to another point of reference or whether it is some precise GPS coordinate. So without that information, how can anyone determine that this boundary has a certain location? But turning back to whether these coordinate locations exist or not, I think there's conflicting evidence in there. Certainly, Mr. Summerfield didn't say that. He didn't provide the information. There is that one email where one of the GIS employees state that, but you also have to look at what the other GIS employees said. Is that when you create these buffer areas, you do it based on some other point of reference, either a property line, right-of-way line, or street center line. And that needs to be determined. You have to be able to determine that to determine where this precise location is. That's in the emails, not one that I handed you, but I believe it's maybe Exhibit 3 to my material. So their own statements suggest that you just don't look at the precise coordinates. And Mr. Miller's affidavit, I think, also addresses this. Again, these buffers are created or offset from some other point of reference. And that point of reference is determined by the underlying map. They have to draw property lines or they have to use center lines, and they use the county's GIS information to do that. They overlay it. And so and the county updates these maps, I think weekly is what we were told, and property lines are changing all the time. So the county has to do that. And sometimes they change, sometimes they don't. But because of those changes, if you have offset it from the center line and you get a new survey of King Street that says the center line is actually 5 feet to the west, that's going to change that offset line. And so Mr. Miller talks about that in his affidavit, that these lines are changing. And so if they change, they're not certain. So for those reasons, we don't think you can determine it based on those GPS coordinates to the extent that they exist somewhere. Your question is good. Yeah, if you get on the online interactive map, you're not going to be able to find that. I don't even think it has a scale. So to a layperson, even to staff who doesn't have the advanced GIS tools that the GIS department has, they have to guess. So again, that goes to the uncertainty of this line. But I'm just going to reemphasize the point. Nobody has said where this line is, whether it's in relation to the property line, whether it's to the King Street center line, or whether it's some GPS coordinate.
What about the question of the survey? Is that, do you know whether or not you or your client has explored getting a survey of the property to try to undertake the location of that line with more precision?
No, we haven't, because we were not given that information, I believe, until after we filed the appeal. Again, this got remanded back to the zoning administrator. Based on the information that we have, we believe that he was involved in this determination prior to BAR approval. The information that we've received since then proves that to be correct. So when we asked for that, we didn't know we needed a survey. We're lay people too, even the architect. She's not a GIS expert. She's having to guess. She's going to the city for direction. So we were never told that. We've seen numerous emails of other developers, other property owners dealing with the same issue, maybe not with the height district, but there are other base zoning layers that split properties. And never have we seen the zoning department, the zoning administrator, Mr. Batchelder saying, no, we can't, you have to go get a survey so we can determine this precise location. No, it's just been applied. I think there's an inherent understanding that we cannot rely on these GIS boundaries that intersect the property. So if that were to happen, it would be unprecedented. And I think unfair to 657 King Street to do something that has never been done to any developer merely because they follow the direction of the city of Charleston.
And that, and is there more on that? And I'm gonna ask Mr. Summerfield about that because honestly, that is concerning to me. But I've heard about one meeting where a staffer said, oh yeah, the uncertainty applies. Are there other statements that you can point to by other city officials in the record that were relied upon by your client saying, yes, follow the whatever the number is, follow the uncertainty provision?
I don't believe there's anything that direct in the record. What you will see is the transcripts from the VAR meetings where the discussion of 54-103C was addressed. And I think certainly implicit in that is that if this applies, there had to be first a finding of uncertainty.
Was that hearing contested?
It was contested by Historic Charleston Foundation, I believe Preservation Society of Charleston also making the same points that they raised on appeal. We don't believe this applies because it requires uncertainty and we believe there's certainty. So those issues were raised and they were rejected.
And so,
Clarification.
okay, Ms. Jennings, come on up.
My apologies. I just want to make a clarification. The first time we had the VAR review, when this was presented, we were deferred. And we didn't get any response from Historic Charleston Foundation about that part of the application until right before we went to the second conceptual review with the same clause being cited in the second.
And while you're up here, I just wanted to be sure that I'm getting a full picture and full record. I heard about one meeting where you were advised that the city thought that there was uncertainty on that line from one staffer. Were there other communications to you in writing or orally where the city represented to you that the uncertainty standard applied?
Yes, we received an email explaining it
Yeah.
from BD Wortham Galvin.
Is that email in the record?
I'm not sure if it is.
When I look at page 11 of your documents you provide, I think at the bottom of the last paragraph,
Are we moving back to Mr. Gaskins or are we talking with Ms. Jennings?
I think they're both participants.
Okay,
I
all
think
right.
we're talking to Mr. Gaskins because he's the one who prepared this
All right.
response.
Page 11.
Page 11, the last sentence on that page and the a little bit on the next page 12. We talk about Reliant for GIS purposes.
Was there a question? Sorry.
Mr. McKay had a question.
Well, I think it gets back to the question that you were starting down, the reliance. Can you rely on this to prepare a survey? And the statement that y'all make on page 11 is you cannot rely on this to prepare a survey is how I read that. I'm just asking you, am I reading that correctly or incorrect?
Yeah, that is our position. I think what you may be referencing is an email that summarizes our meeting with the GIS director and Mr. Overcash from the planning department.
Did y'all get concurrence with the surveyor that they cannot use the GIS information to prepare a survey?
No, we did not. We engaged Mr. Miller instead.
And Mr. Miller is not a professional licensed surveyor, right?
Can
He is
I
not surveying.
I
Go
wanted to ask a little bit more about your question too, in that same line. Regarding your exhibit 20, since it's regarding 483 Meeting Street, can you explain again the process? I know that we're talking about it a little bit, but maybe go step by step that the applicant went through to confirm the height district boundaries prior to commencing the project?
Are you talking about exhibit 20 or
Well,
657
in
King.
exhibit 20, you reference, or you cite information from Brian Pokrant regarding the GIS information. I'm assuming to illustrate that that information is not reliable. So my question is, it's kind of going back to what, Chair Tibbles is saying or asked, is that, what process did the applicant go through to ensure that that information was not reliable or was reliable? I think someone else asked, was the zoning administrator officially or formally asked that question or formally provided, an answer whether or not it was reliable or where the boundary was? So I'm just curious again to know exactly what was done before the project, besides the letter, I think that the architect or the email the architect had regarding that information with staff. Because I feel like there was information referenced in your document that talked about meeting with planning staff and preservation staff, and I'm not sure if I'm clear on that.
Yeah, maybe Ms. Jennings is the best person to answer that question, but so the process was applicant initially attempted to design the building to comply with the 4-6 zoning, height district zoning, where the front portion of the property would be 4 feet or 4 stories and would step up to 6. They got that application was denied and was told to go with a more consistent approach, which is then when the engagement with city staff occurred between Ms. Jennings and staff. I'm sure Ms. Jennings probably looked at the GIS herself and tried to make a determination about where that line is. And probably like any of us who attempted to do the same thing, could not determine exactly where it was, which led to additional discussions with staff. And the information that 54-103C will apply, and that you should go with 5 stories across the entire building, which is what they did. Went to the March meeting, which was deferred. There was some discussion about this, but there was no objection to the height. It was to look at mass scale, other issues, not to the height. And so they redesigned it with collaboration with HCF, or taking their comments into consideration, trying to accommodate their concerns. And they were told, we don't have any concerns. We're not crazy about the height, but we're not going to object. And then at the last minute told, oh no, this could set a bad precedent, so we have to speak up. And so there was further discussion at the BR meeting in May, and it was ultimately approved.
Thank you.
Sure.
I just want to clarify that we obviously do have a survey for this site. That's what we were using for design. And Ashley did reach out to the city prior to our March meeting. And that's when we were trying to determine where the line was. We were told that from BD in an email that they didn't know, so it deferred to this clause. And we later saw our project on the news with Mr. Summerfield being interviewed about it prior to that BAR meeting in March, not the one that was appealed in May. So we were under the assumption that he was involved with the decision, because he obviously was talking about it on March 11th prior to the March 12th meeting. That's why we were under the assumption that this had all been determined by the city and we were moving in the right direction. No one brought it up or questioned it after the March meeting prior to the May meeting. And we continued to spend money and design in the direction that the city was telling us to go in. And that's how we've ended up here today, a year later, trying to figure this situation out.
So I guess my question, just to follow up with that, is the city advised you to design a 5-story? That's a
Yeah,
5-story.
yeah, they advised us in writing that, right?
Well, just to back up a little bit, when we first started the project, of course, we wanted to know where the line was. And this was way back when we first started the project. I was meeting with BD Worthing Galvin, she's the city architect, to go over the project. I asked her where the line was. She went back to the office to determine where it was. And she said, I don't understand how to locate it other than to overlay the zoning map on your survey. And that's what we did when we first determined where the line was, when we first did the conceptual design with the step up from the 4 to the 6. When you do that, the line that you overlay from the zoning map becomes about 5 feet wide because you're blowing it up. So we took that as a general, like, let's take it in the middle, but that was what we used when we originally designed the building from a 4 to 6 story building. The reason that we went back with an all 5 story structure is because in our first BAR conceptual approval where the project was deferred, they asked us to reduce the number of stories to 5 stories. That was a suggestion that was brought up by the Preservation Society, was to reduce the highest point of the building to 5 stories. And we assumed that the city adopted that as part of their deliberation, learned later that that was not the case. I think we learned that after the appeal happened. But the idea of coming back with a 5 story consistently across the property, and that's because the building is seen in almost 3D because of where it's located. And so we came back with a complete 5 story building, thinking that was the direction that we got from the Board of Architectural Review.
I have a quick
We
question.
tried everything in our power.
In your BAR presentation, did you present the GIS data and talked about the differing heights?
We did in the initial meeting when we had
That
the board.
was in front of the board.
In front of the board, we just mentioned that we knew we needed to step up in that first meeting where we were trying to meet that 4-6. But they didn't like the design.
We tried. We didn't ask for this ruling from the city. We tried everything in our power to figure out where this line was. We were told they couldn't determine it. And that's how we ended up in this position here. And they obviously can't, because they had to rewrite to amend the ordinance to fix this issue. And we've been stuck in the middle of it from then until now. So that's all I have to say.
All right, thank you, Mr. Colbert. So Mr. Summerfield, I have a couple questions.
Yes, sir.
Your ruling on this issue implies that the boundaries location can be identified with coordinates or measured distances. Is that information that you have supplied or you can supply to the appellant?
I believe it was supplied as a part of the metadata that was given to them by GIS, but yes, that can be supplied if, again, we give it to surveyors all the time when they ask for information about any of our layers where we've created shape files. Again, our GIS is, there's a base plate that comes from the county, but then there are literally hundreds of layers above that. In the zoning portion, there's probably, with all the overlays and what have you, there's probably a good 25 or 30 layers that then overlay the base zoning information or the base mapping information that we get from county GIS. But we build those aren't county elements. We build those with our GIS department, and they do a couple different ways to do it. In the case of the Heights District overlay, that's built with polygon shapefile as was discussed. And that is something that we have as an independent layer that we can supply to anyone who wants it. As noted, it because of the way the costs associated with GIS, and for those of you who have access to the full like Esri suite, that they break it down to become more cost effective to provide to the general public. Those are basic tools. They do not have the same degree of information that I have in my office, but I also don't have the same degree of information because I'm still using a cloud-based solution as the folks who have the mammoth towers that run the hardcore desktop versions of GIS. But yes, the data is available. Like I said, I believe during the FOIA process, it was provided by our GIS team, through the FOIA. So that layer should be something that the appellant has as a part of all of that. If for some reason they don't, we can provide that, yes.
And the district boundaries, I think I heard Mr. Hellman mention the district boundaries are measured with reference to other district boundaries and not to right-of-ways or property boundary lines. Is that correct?
They are static lines. So as has been mentioned, there's always, no, not always, but there are slight tweaks to street right-of-way widths and other things as updated surveys do occur. As you might imagine, in a community as old as ours, our understanding of boundary lines and what have you have changed. And so we do get updated surveys that do adjust those, and when those are recorded with the county will update the base layer. But this is a static layer, so it doesn't change because the base layer moved in a right of way is here and there. It's a base layer that when geo-referenced by a surveyor onto a survey will show you where that overlay, because again, it's an overlay. Almost think of it back in school. Well, maybe you're too young, but for the rest of us, we all went to school back in the day when there were overhead projectors and the teacher would bring the overlay in. Well, it's the same concept. We overlay that onto those base layers, and sometimes those base layers have adjusted, but the height district map is static. It only changes when we adopt an updated map based on council action to update the overlay.
And just so I understand your decision or your determination is not that line is known in reference and proximity to the boundary of the subject property, but that it is knowable. Is that right?
Correct. And I want to be clear, when the appellant was in the office and we were in the conference room, all of our discussions centered around distance from street right of way, from the property line and street right of way. And he's absolutely correct. One, again, the cloud version that I have, while better than the public version of GIS, in terms of having some better tools, is better. It does require a very steady hand on the mouse to get to a certain level of precision, and I was not able to get a consistent.
Is that what I saw in the appeal that you, I think it was something like measurements were consistent.
Yeah, they were in the ballpark, to use Robert Houck's language, I think. They were in the ballpark of 50-ish feet from the property line, but correct, no individual measurement that I did that day with the appellant there could I get the exact same decimal point feet measurement from the property line, which is what would be recognizable to all of us on the map. But for a surveyor taking the geo-referencing data or the GPS data, the polygon data, and geo-referencing that onto the survey, they would be able to
So
make that determination.
just because you couldn't do it on your software with your equipment, with your mouse, with your hand, that it's nevertheless doable. It's
Correct.
not something
That
you
was my
were-
determination, that it is not uncertain or ambiguous, in my opinion, that it is certain and knowable.
Right. The appellant requested apparently 9 specific pieces of information in its October 24 letter. Why didn't you address any of those in your determination?
Because at that time I was working, I believe that's, and I'm gonna look over to my attorney, that is during the time that I was working on the remand from the court, correct?
Would have to look back, I can't tell. That may be the case. I'm not certain.
I believe that is at the period where I was working at the remand, on the remand relative to from the court related to this issue. And I received letters, stating positions and requesting some things from both sides of this case. And at the time, I was not writing anything other than, and as you can see in the letter, it's a joint determination to both sides of the case until after I had completed my review and my response on the remand issue. And at that point, then, once that was issued, we got the FOIA request, and then we were providing a bunch of information anyway.
Were you aware before the May 2025 BAR meeting that city preservation and planning staff had advised the appellant applicant to redesign the project based upon boundary uncertainty?
So that's a more complicated question than you realize.
Okay.
As has been indicated by the appellant and is clear in the record, so, and as I know you all are aware, so presently I wear two hats. I am the Director of Planning and Preservation, and I am the zoning administrator. So in my role as Director of Planning and Preservation, I also serve as a city spokesperson for the whole Department of Planning and Preservation, which includes the BAR. So for any of you that have familiarity with being a media representative or a spokesperson for your organization, you get talking points from the people who are doing whatever the project is that you're supposed to speak in front of the reporter for. Often you get those, if you're lucky, a day ahead of time, because you're lucky if you get a day ahead of time before notice on when the request for media consult is. And then sometimes you get them 10 minutes before. So in the big universe of, did I do a TV interview where I spoke about this project and my role as the department director and a spokesperson who received some bullet pointed talking points from our team? Yes. As the zoning administrator interpreting any rules with regard to whether the separation between the two height districts, no, that discussion never came to me as zoning administrator, and it was never specifically brought up to me in the context of that media interview that I was doing. There is a notation in the bullet points, I think, that does indicate, because it was one of the facts of the thing, is that there is a split height district. That didn't come up in the media request. So to be perfectly honest, I don't recall ever having paid real attention to that.
Okay.
Part of it.
And when you recommended, you recommended approval of the application, at the May?
To be clear, I never recommended anything.
Okay.
The city's architect, and as the representative for the Board of Architectural Review staff, as the board administrator for that stuff, just as I sit as zoning administrator, as the representative to this board from staff, she sits and is the administrator for that board. She produced those staff recommendation and the staff comments. As you see, and I believe there's another email that is in the appellant's thing. Once again, as the department head, I forwarded to the section chief, who Tim Keene, who was my boss, what the department stance, as in the division of preservation stance, was related to this item, not the zoning administrator's stance, because again, the zoning administrator never reviewed this. I never reviewed
You
this.
were never
Hey,
asked to review it.
I-
given it-
again,
That's my question too, is would you typically review it if the city architect or the director of preservation or be our staff liaison, would you typically review it if they've already
no.
signed off on it? I mean, is it something that you would have formally reviewed?
I don't
and
get
given-
involved unless an issue is brought to my attention
Somebody
that
needs to make
needs.
a specific request.
Yes, unfortunately, we operate in a very reactive mode. I wish we were able to be more proactive, but just the volume of work and the resources we have, we're reactive. So unless something squeaks, it doesn't get oil, if you would. So unless someone has told me, hey, there's an issue, a concern, or whatever, and that gets raised to me, which in this case, and I'll be honest with you, I don't know enough of the chain of the communication as to why this never got raised as a question to me. It did not until the court remanded it back to me, because it wasn't until after there was an appeal that I was even aware that, again, we had an issue, and at that point, it's already in the court process.
Okay. You were never advised or made aware of it prior to the VAR hearing.
I was not of this use of the 103 language, I think it's 103, one something, and not that general provisions language about the uncertainty about a boundary line, that was being utilized. Again, I was not made aware that that was happening until basically the appeal and everything blew up at that point of that final hearing.
All right, does anybody else have a question for Mr. Summerfield? Yeah, we'll get to you in just 1 second. We'll let you have another second.
Yeah, I guess, do you think that you should have been made aware, and by whom? And at what point? Because I don't see why the applicant would have brought it to you if they were under the impression from, you know.
So again, that's a complicated answer. I think there, to be perfectly honest, was 3 points of failure with regard to where and when I should have been brought into the conversation as the zoning administrator. The first point would be the applicant. As a part of any BAR submittal, you are supposed to ensure that you've resolved all zoning issues prior to BAR, because again, BAR is not the zoning team. They are not addressing zoning issues. And one of the key elements that's on the application for submitting to the BAR is that you've satisfied all your zoning issues. That said, I do think in this case, at submittal, they probably were meeting their zoning requirements because they had shown a set of plan that showed the step up and the step back for the height. So at the point that changed, someone should have brought me in. I'll be perfectly honest, it probably should have been city staff because that changed in the process versus prior to the applicant bringing an application. That said, I also know that, you know, all the parties involved in this do a lot of work in the city of Charleston, and I have conversations with them, and I know Lee has had conversations with them regularly on other projects not related to this one. So it's always been a concern really related since all this came up that honestly, no one from the BAR team, from the applicant side, and then, you know, once this started getting into conversations with other folks in the city, why no one came to speak to me on this. On that part, the code is pretty crystal clear. It's the zoning administrator's responsibility to interpret the code. And so the fact that no one came to me on something that's clearly an interpretation issue is worrisome. It's been addressed internally and it will never happen again that way. I think there's definitely a lesson that's been learned by all of us involved. But yes, I think there were multiple places where someone could have come to me before this became the thing that it is today.
Do you, since it's been expressed that some concern about a precedent being set, if this were allowed to happen, do you believe a precedent would be set if the city staff made the decision?
So I think there would have been an assumption by some other developers that this would be an opportunity to question not just the height district lines, but other lines that may cross properties and aren't necessarily related specifically to property lines. Unfortunately, in the city of Charleston, we have traditionally allowed zoning to actually be split zoned on a property, which is not necessarily a best practice. So I do think that there would be a concern for that. I do also think, though, that one of the things that we did, and I apologize, I can't remember who kind of hit on it earlier, was part of the reason that amendment was made was because I think it was the appellant's, I think it was Mr. Hellman, who had mentioned that he had talked to Lee to find out where that code provision well predates the current height district overlay. And it does come from a time, a lot of places had similar provisions in their codes from a time when GIS was in its early days and did not have nearly the amount of data behind it that it does now. when paper maps were used, when zoning was quite often, or future land use was more of a bubble map. And it wasn't a a property by property, parcel by parcel kind of delineation that it eventually evolved to, even in the paper versions. So I think now we are saved from that because our legal team quickly, once this was raised as kind of a question, closed that door on anyone else being able to try to make that claim that the line in GIS is not the line. But I think had that previous portion of code remained and that this had gone forward, again, I will leave it to the lawyers on, because precedent has legal implications, but I do think that it would have signaled to some folks in the development community that maybe there's an opportunity here in something to attempt to take advantage of.
Anything else for Mr. Summerfield?
I have one
Yeah.
question. So, and I'm just reading, so from during the meeting y'all had on December 8th, y'all, let's see, you stated the high district boundary was 50 feet from the property boundary adjacent to King Street. I'm just generally curious, is that, now I realize you were taking measurements and you came up with, roughly a ballpark, worked out to about 50 feet. Is there any historic record as to how that 50-foot was originally established? Someone drew a map at some point.
Yes. So and again, this is one of those things where, because I wasn't here, I don't have any firsthand knowledge. What I have is anecdotal and from looking at various documents that were produced at the time. When DPZ, which was the consultant team that was brought in to assist the city with the creation of the modern BAR and specifically the modern height district regulations. There are some documents that were produced. There's some handwritten notes on a few maps. There is within presentations, I even found one. Well, no, I can't claim I found it. Christina in my office found one that does include one reference to moving the line based on a specific measurement distance to the right of way. Unfortunately, there is no index matrix clear answer. You look at it and it's, again, in hindsight, it looks like they clearly had some measurements and intentionality when it was originally set up. And again, it has evolved from the original adoption in August of 2017. There have been a number of height district amendments that have kind of changed the original context of the map. I mean, just a block south of this, when you look at the Courier Square Phase 3 site, the old Post and Courier building, that site got a significant rezoning with regard to height district that really compartmentalizes some different height zones within that site. Again, that said, unfortunately, I do not have anything that we've been able to find when we reviewed all of the information, and no one that was here at the time, they all remember a conversation, but no one remembers anything with the exactitude to be able to make any kind of definitive statement as to how they measured. Did they change it in different parts of the corridor? Clearly they did, but again, all of that's anecdotal and hindsight looking, not factual, in that I have a record to demonstrate it.
So I think that answers my question. My other question is, when you or zoning is approached by a surveyor to establish those coordinate locations, give me just a 60-second explanation of what happens next. How does, what do
They go to GIS or they do a FOIA request, so I don't know.
Okay.
I'll be perfectly honest. When a surveyor is pulling that data, that none of that never crosses my desk, so I'm not sure exactly. In fact, I don't know that maybe someone that works on our mapping review side, maybe has some, but to my knowledge, they go straight to GIS to pull the relevant layers and to get the shape files to place on their drawings and then make their drawings from there.
So a licensed survey would do that there. I mean,
Oh, yeah, absolutely.
I think that's the other thing I'm sort of noodling over, within the standard of practice for surveyors, there's completely different. There are different standards for like a Class A survey versus a GIS accuracy. Very big difference between those two. So, I guess my feeling is even given GIS data at a 1" to 20" scale, your accuracy is like 0.7 feet. So you're still within, you might be within a foot, or you might not be just for that one data point. But for, an actual survey out in the field, that's a much higher percentage, because it's 100 foot. But I feel like there's still a very broad disconnect between the GIS information and I don't know, I guess, the real point ordinance.
I would think that once a survey has been prepared, then the city has to
And only they know.
approve the survey at that point.
Yeah.
And then everybody has agreed that those are precise and acceptable points.
All right, any further questions from Mr. Summerfield? Or we exhausted him?
Not yet.
All right, so Mr. Gaskins, I told you we'd hear from you, and we'll hear from anybody else who wishes to speak, and then I'll entertain a motion to go into executive session.
I'll make two very brief.
Yep.
With respect to Mr. Somerville's recitation of the timeline and his involvement, I think the record speaks for itself. The media request came early March. The day before the meeting, he received the email from BD that expressly talks about the 4-6 hike district and that we're recommending going to 5 stories. After the meeting, he tells Mr. King, we recommended approval, but it was deferred. In April, he forwards an advocacy column, editorial, whatever it is, that specifically raises this issue to his bosses and one of his subordinates. He had to have been aware of this issue. And this is not the case of some rogue, overworked, under-resourced employee making this decision. The record reflects this was a carefully considered decision made with legal and subsequent to it, backed by the city's attorneys. So this was thought out, it was considered, it was deliberate, and it was the right decision initially until he reversed course. Secondly, with respect to your question, well, what do they do once they get GIS coordinates? I don't know if it's ever happened. I would like to hear Mr. Summerfield's answer to that. Has this ever happened where where planning department, the zoning administrator said, we can't determine this based on this. You need to go out and get a survey and then we'll put the coordinates on there and determine. I don't think it's ever happened. Has it?
I have never had anyone in my time with the city use the uncertainty. We use surveys all the time.
And it'll never
property
happen
lines.
again.
Right.
So, all right, everybody have a motion?
Move to go into executive session.
Thank you. Second.
Second.
All in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously. We're in executive session. We'll be back.
Chris is gonna go in.
Just
You
for the
guys
record,
just,
to state the purpose of the executive session, we're gonna go receive the vice.
You're not invited on the party.
No, we're not allowed.
That's Hayward Brimble. He's an attorney with Richardson Platt, and he's representing the board.
Okay. Okay. I believe that's a conflict.
Yes.
Are you?
And I'm representing the city. Tim Doman is representing the BARL. And now we have simply council board.
Allow you have separate council.
Would you cause, raise that whole issue?
I'll make sure all our boards are independent and independently represented. Where
Okay.
we have concentration of issues.
So Tim Doman is representing the
BAR.
VA. And
Yeah.
this gentleman is representing who?
Board of Zoning Appeals.
Okay, down,
Yeah.
okay.
This
And then
board, this.
You're
That's why he
representing the
was-
staff, he's representing.
You're representing us, he's
That's right.
Yeah. Oh,
And- Yeah.
So I just want to clarify that what I remember is that the city ordinance amendment is just saying that GIS is what should be referenced to make a determination. So
Yeah.
So the idea that everything is fixed is not the case. I mean, if they come back and this is a problem, then there's still all a problem.
Well, shouldn't just the uncertainty provision be stricken? I mean, if it is indeed a remnant.
Did the
of
ordinance
like the
pass?
old-
Well, that's what
Yes.
that ordinance redid. I mean, it basically said.
It takes
included-
out this, it also puts any dispute about the location, it references the scale on the GIS
Right.
map, but then it
GIS.
puts it to zoning administrator.
Right.
Which then gives an appeal from any dispute regarding your interpretation to the board.
But the idea that GIS is what is used.
But the measure on the scale of GIS is what's used to then use that information to apply it to a parcel,
Right.
and then have that GIS, those geo coordinates, whatever the term
Right.
is. The GIS does a surveyor would superimpose and survey.
But you see what I'm saying, like that.
Nope. And the mic is back on. The mic is back on. Not touching recording, but I did turn the mic off while.
All right, I need a motion to come out of executive session.
Move that we exit executive session.
All right, the motion is made by Mr. Bennett, seconded by Ms. Grass. All in favor, please say aye. Aye. Any opposed? None are opposed. We're out of executive session. No action was taken. No decision was made. I did indicate that I would hear from anybody who wanted to speak after I gave Mr. Gaskins another opportunity. Is there anything anybody else wants to say? All right. This is a thorny problem. Mr. Gaskins, I have one other question for you, and that is, would your client be prejudiced if it could determine where the line is and the line is located in its favor? Couldn't it go and reapply to the BAR?
I'm not sure I understand the question.
Yeah, I mean, if the line is ascertainable, and if the line as it exists on the ground would be such that it enabled this split zoning on the height, could they go back and reapply or no?
Not with the same proposal, because I do not believe that section 54-103C would apply if there was a determination that the location of that boundary was certain.
Okay.
So yes, I think they would be prejudiced by that.
And if the decision, if the appeal is denied, the applicant appellant would have remedies in the circuit court, both for estoppel and an appeal of this board's decision. Is that right?
I believe so.
All right, thank you, Mr. Gaskins. And just for the circuit court to hear, if I were sitting as a judge, I would require the parties to go and obtain a survey. And I would ask that the surveyor, a licensed professional surveyor, provide an opinion as to whether or not the line is ascertainable. We've heard enough, I think, to support the zoning administrator's decision that it is ascertainable, but I don't know where it lies, and I think a surveyor is what was missing here with respect to, number one, can it be ascertained, and number two, the exact location. That was something that would have been useful for this board to have to consider in any event. Have further discussion among the board members, or entertain a motion, whatever you like.
I'll make a motion to deny the appeal and to affirm the zoning administrator's determination.
All right, we've got a motion made by Mr. Huey to deny the appeal and affirm the decision of the zoning administrator. Is there a second? All right, Ms. Grass seconds the motion. We'll vote all in favor, and again, just to caution you, an aye vote, a yes vote is a vote to deny the appeal and affirm the decision of the zoning administrator. All in favor, please say aye.
Aye.
Any opposed? None are opposed. The decision is unanimous and the appeal is denied. I would be remiss if I didn't commend both attorneys for excellent presentations and representation of their clients, and it always makes it easier for us when we have excellent lawyers like both parties had this evening. So thank you very much.
We need to make a motion to adjourn.
We don't need a motion for that. We're adjourned.
Yeah.